the of employees to be able to organize if they personally so see fit, and to negotiate the terms and conditions of their employment through representatives of their own choosing. This particular law is considered by many to be the predecessor to the National Labor Relations Act that was passed about 3 years later. During a period of labor unrest, and for example, here in the state of Montana, we had a lot of labor unrest in the Butte area, and there was a group of people known as the Wobblies that were basically socialists in Montana, and they're the individuals who the action between the Wobblies and the mines resulted in the folks who over that issue bring in the U.S. Army to try to quell the various kinds of problems that existed at the time. So in those days of unrest, a lot of times employers would go to the courts and seek injunctions against the people who were seeking to organize strikes. So injunctions and the restraining orders were substantially limited by the Norris-LaGuardia Act. So what we really had is over the period of some 20-odd years is we had the pendulum that had previously been very much in the employer's court with the Norris-LaGuardia Act started to swing back towards being more pro-employee. After the Norris-LaGuardia Act, the next law was the Wagner Act, better known these days as the National Labor Relations Act, and it was passed in 1935. That particular law still exists today and is still very much active because it is the law the National Labor Relations Board enforces. But the NLRA actually grants employees two basic rights, and they're found, for example, in Section 7 of the Act. One is the right to form or join or assist a union, and equally to refrain from doing those things. And secondly, the right to engage in what are known as concerted activities. And the term concerted activities basically means when two or more employees get together to engage in some sort of activity to try to enforce their rights to negotiate. Concerted activities most commonly are things like strikes, but they can also be things like sounds or scouts or various other kinds of actions that are intended to put pressure on the employer so the employer would acquiesce to the demands of the union. But the right to do that is a right that's guaranteed by Section 7 of the National Labor Relations Act. So the NLRA also once again reiterated the right to organize, required employers to bargain with employees collectively through employee elected representatives. It guaranteed the right to engage in concerted activities for collective bargaining purposes, meaning either to establish a contract or to enforce provisions of the contract. And finally, it created the National Labor Relations Board, which is an organization of 5 citizens that are appointed by the president to serve and oversee the enforcement of labor management types of issues. Then, a dozen years later, Congress passed the Taft-Hartley Act, which is more officially known as the Labor Management Relations Act. It's an amendment to the Wagner Act, and it did several things to try to lessen industrial disputes. One of the things that it provides for is what's known as a cooling off period. And you may be aware that occasionally there will be a threat of a strike in some sort of industry like trucking or railroading or something where the impacts of the strike can be felt nationally. The President has the authority under the Taft-Hartley Act to order a 90-day cooling down period which basically is a legal prohibition against the employees going out on strike so that those national interests are not negatively impacted. And you see Taft-Hartley actions every 5 or 6 years. You'll see some threat of shutting down the auto industry or the steel industry or transportation or railroads or lines, and you'll see the owners of those businesses go to the president to try to convince them that the national interest is at risk. And the idea would be if the president should agree, they would invoke their rights under the Taft-Hartley Act to cause a 90-day cooling down period that hopefully would result in the parties coming together and resolving their particular disputes. A dozen years later, there was another law called the Labor Management Reporting and Disclosure Act, and it was passed largely in response to concerns that unions were doing things improperly. For example, that they may be using pension funds for inappropriate purposes or other kinds of things Congress thought were inappropriate. So Labor Management Reporting and Disclosure Act requires the unions to report certain information to the federal government, with the idea being that will help reduce the amount of violations that may occur. You may not be aware that the National Labor Relations Act does not apply to the rail and airline industries. They have their own law known as the Railway Labor Act. So it recognizes the fact that those individuals often work in multiple states, even on a given work shift. And so it's written a little differently to protect the rights of those particular individuals. It also provides mechanisms for settlement of labor relations, disputes that involve pay and working conditions, and the other kinds of things that often come up in labor management disputes. And then finally, there's another law remembering that the National Labor Relations Act does not apply to governmental employees. The federal employees are covered by something called the Federal Service Management Relations Statute that puts the right to negotiate with the federal government, but only for a very restricted set of rights. You remember what was known as PATCO, and PATCO was Professional Traffic Controllers Association back under President Reagan's term, and they had a concerted action, and it started to slow down national air traffic, and President Reagan fired everybody because of the fact that the National Labor Relations rules, the Federal Service Labor Management Relations Statute, does not permit federal employees to engage in concerted act. It just allows more restricted things like filing grievances or some restricted negotiations with regard to compensation. So one of the terms that you'll hear that's used a lot with the concept of labor management relations is the term called ULP, or unfair labor practice. So unfair labor practice is the term that's used to describe violations of employer or employee rights under the National Labor Relations Act. So there are certain kinds of things that are considered to be unfair labor practices. One of those is employers may not dominate or support a labor organization. The electronication ruling that I referred to there goes back 20-odd years, and was a decision in which the employer had he's made up of employees that met with management and discussed various things that occurred in the workplace, and the National Labor Relations Board ended up concluding that the employer had voluntarily recognized the union in the regard to this committee actually negotiated with management, and that's what unions do. So there was a period of time, and it's somewhat subsided now, but we still have issues with regard to employers needing to be careful that they don't relate to employee committees in a way that can be viewed as meeting and negotiating with those committees. The proper way to deal with it is the employees can certainly get together, the employees can certainly offer their input, but management shouldn't put itself in the position of saying, whatever you come up with, we will do, or they shouldn't sit down and negotiate. They rather should simply say, we'll take that perspective under advisement and we'll let you know what we come up with, because anything more runs the risk of the declaration by the National Labor Relations Board that you've involuntarily created a union. Another thing that's an unfair labor practice is discrimination on the basis of labor activity. That typically takes the form of some sort of retaliation against the folks that are viewed to be the, quote, troublemakers, unquote, because they're the ones that are trying to get the union to go after high pay or bettered working conditions. So officially, the issue of whether somebody is represented by a union is an issue between the employee and the union. And while we all know that the employer is impacted by that decision, ultimately, if the employer does anything to interfere with that right of the employee to make their own decisions, it can be viewed as an unfair labor practice. Similarly, if the employer retaliates because the employee in some way filed an unfair labor practice charge with the National Labor Relations Board, that can be considered to be a separate and distinct ULP. Employees are forbidden from interfering, restraining, or coercing individuals with regard to becoming involved or not becoming involved in the labor negotiations process. So restraint would be to put up artificial barriers to people participating in a union meeting. Interference might be the form of taking photographs of who's going to the union meeting, retaliating against them, that sort of thing. Unilateral actions, to the degree they deal with mandatory subjects of bargaining, are unlawful. So what that means is, if you are an employer and you have employees covered by a collective bargaining agreement, and the union agreement calls for pay of, say, $10 an hour, it is actually unlawful for the employer to pick out a given employee or group of employees and give them a pay raise, because that's a subject matter that's covered by the contract. It no longer becomes an area where the employer can act without meeting with and negotiating with the union with regard to that particular subject matter. The process of forming a union can happen in one of three ways. One is what's called voluntary recognition. And voluntary recognition is where individuals who are seeking to organize a group of employees go to the employer, and the employer basically says, fine, I'll negotiate with you, and they just voluntarily allow the employees to organize. The second is what's known as involuntary recognition, and that often occurs when there's been some form of an election in the employer has acted in a way that so poisons the well that the National Labor Relations Board orders the employer to recognize the union, because the continuation of the election process would not be fair and representative. You don't see that happen very often, but I've seen a couple of cases where the employer has just acted so outrageously that NLRB ordered them to recognize the union. The third most common way is through election. And the election of a union basically happens through the filing of a petition that shows that the majority of people, well, actually at the petition stage, it only has to be 30%. 30% of the people who would be in the proposed bargaining unit. So, for example, for a given employer, they might say all the people who do the following work are the potential members of the bargaining unit. Maybe that would be all welders or all registered nurses or whatever it happens to be. So if at least 30% of that group of people file a card that's called an interest card, and that's filed with the National Labor Relations Board, the RB then schedules an election, typically 4 to 6 weeks in the future. So the period of time between when the petition is filed and the election is held is normally referred to as the campaigning period, during which both the employer and the union both can lie to their employees and show them why voting for or against the collective bargaining agreement is in their best interest. One of the things that an employer can do in the process of forming a union is they can voluntarily recognize a union. The way that can occur is if the representatives who are trying to form the bargaining unit come to the employer and say something like, would you like to look at these cards of people who are interested in the union? And if the employer says yes to that and looks at the cards and more than half of the folks who would be in the proposed bargaining unit have submitted cards all over, that's perceived to be voluntary recognition. So employers have to be careful what they do and who they talk to during this particular period of time to make sure that we're not in a situation where we voluntarily recognize a collective bargaining unit. Things that will preempt action by the National Labor Relations Board, and they fall into the list that's on the slide that you're currently looking at. The first of those is what's called a contract bar. That normally arises in situations where you have Union A that already represents the employees and Union B wants to represent them. What a contract bar would do is it would prohibit the Labor Relations Board from conducting an election while there's a valid collective bargaining agreement in place. So in other words, the new union can come in and try to raid the existing relationship until the contract has expired. There's a window for filing a representation petition when there is an existing contract, and it's the period of time that's more than 60 days but not more than 90 days before the expiration date of the existing contract. So what that means is if you have a group of employees that have, let's say, a 3-year contract, when you near the end of that contract, within that third period of time from 60 to 90 days before the expiration, then this other union could come in and file a petition saying something like the employees no longer feel Union A is doing a very good job, and that result in there being 3 choices on the election, 1 choice for no representation, a second choice being for the current representative, Union A, and the third choice would be for a potential alternative Union B. An bar keeps the union from beating the employer to death with repeated elections. So once there's been a valid election, another election cannot occur for 12 months. So generally that refers to if an election and the union loses, they have to wait for a year before they can come back and ask for another election. A prior petition bar would prohibit a union that has withdrawn an election petition for refiling it for at least 6 months. So there will be situations under which the union is trying to have a point of interest. Something causes them to think we need to do more work before we have this election so they can withdraw that particular petition. And under the prior petition bar, they'd have to wait at least 6 months before starting the process again. The certification year bar basically provides a new incumbent union at least a year of time that they can try to negotiate typically an initial contract. So a new union can't come in again and try to aid the employees until the first union's had at least a year to attempt to negotiate a contract. A voluntary recognition bar, if the employer has voluntarily recognized the union, they have to wait a period of time before they can come back and say, well, we don't think that the union has majority support from the employees in the collective bargaining. Blocking charge would be if there's unfair labor practice charges pending, the NLRB will typically try to fix those or address those before schedule an election. Some employers purposely create unfair labor practice charges so as to delay the petition process, because generally speaking, delay is in the favor of the employer, because union typically comes in promising all sorts of things, and to the extent that the promises aren't fulfilled in a quick period of time, a lot of time the employees start to lose hope that the union can deliver as promised. Bargaining units can be a point of contention in elections. There has to be what's known as a community of interest with people who are in a particular collective bargaining unit. So what that means is there has to be similarity in what the employees do, typically similarity in terms of geographical proximity. So, for example, people who are welders in Montana may not have the same interests as people who are welders in the state of, Washington. They also look at things like a level of shared day supervision and the degree to which management and labor relations are centralized. The more centralized, the more you might be able to have geographical dispersion. To the degree they're all done locally, that makes it harder to argue that we have a community of interest with another organizations where things are done much, much differently. They'll also look at the extent of unionization and past bargaining history, and finally they'll look at the employees' desires to be grouped together in a particular collective bargaining unit. So the community of interest standard can be pretty important. A lot of times when the union comes forth with a new petition to form a collective bargaining union, what they'll say is, here's the people who we think should be in our union. And a lot of times the first point of attack for the employer who doesn't wish to be unionized is to point out that the people in this proposed unit don't have a community of interest. Just as an example, I did a project for a local government, and the local government had asked me to look at people who worked for their library system, and in the process of looking at things, we discovered that they were part of a collective bargaining agreement, and much to my surprise, the union that they were in was the same union that contained the people who worked in the road department. So it's really hard to argue that people with master's degree in library science have a lot in common with people who plow the highways or who repair, because the issues are very different, the working condition issues are very different, the safety issues are different. So to the degree that the employer can argue that these people shouldn't be together, that's one way to slow down and or defeat the process of collective bargaining. So Kim is probably aware that there are certain kinds of units that are pretty much automatically created, particularly in healthcare, because over the years certain principles have arisen, and one of those is in hospitals, all these kinds of people typically automatically are recognized as having a community of interest. There are people who cannot be covered by collective bargaining agreement by law. Those are confidential employees, and confidential employees might be the confidential secretary of the head of labor relations. So if they have access to information about the collective bargaining strategy of the employer, that makes it difficult to have those people be in the union. There's also a prohibition against beginners, trainees, and probationary employees being in a collective bargaining unit, temporary and casual employees, and employees on long-term leave should not be included in a particular bargaining unit. A pre-election requirement, there's a number of things you can do, and there's a number of things you should not do. What you must do, one of those is there's a term called Excelsior list, and basically what an Excelsior list is a list of people who will be in the proposed bargaining unit, along with contact information. So typically what occurs is the union will come to you because you know who all people are as the employer, and they'll say, can you give us a list of the home addresses, the mailing addresses, the email addresses of people who are in this particular proposed bargaining unit. And the Excelsior decision, which is where the namesake for Excelsior list, provides that the employer must provide that list of contact information to the union. You're also required to post official notices of the election, and those come from National Labor Relations Board when a particular election is scheduled. They contain a notice to employees and a date for the election to be held. The campaign is interference with the union is unlawful. You can't retaliate against the union. You can't threaten people. For example, you say, if you guys decide to join the union, I'm closing this shop. That's probably a threat. It's probably unlawful. Now, it's the baby step between statements like that and statements like, if you folks are successful in getting a $2 an hour raise, I will not be able to afford everybody, and I'll have to lay off some people. So the distinction characteristic is distinguishing between a threat and a statement of fact. If you make a statement of fact, you may be required to open your books and prove that it's true. So be careful with your statements of fact, because the union is entitled to see whether or not that argument is true, that we, quote, can't afford to give everybody a $2 an hour raise. So they can look at your books, including the part that you might consider confidential, like your profit and loss, once you make a claim like that. You also can't make unilateral changes to pay or working conditions. And of that might be to say, hey, Josie, if you refuse to join the union, I'll give you a $2 an hour raise. That would be a unilateral action, and distinguished from the person may already be entitled to a raise under some prior promise or contract agreement or personal policy, in which case it would be acceptable. But you can't entice people not to join the union. You can't threaten them not to join the union. Unions are prohibited from striking or boycotting a third party, such as a company, customer, or supplier, as a means to pressure the employer. When I go past particularly at building construction sites, I often see signs that say something like, "This gate is for the exclusive use of XYZ plumbing." And then you go 20 feet down, this gate is for the exclusive use of ABC roofing. And the reason that that's done is because of this provision for what's called third-party boycotts. So if a particular union has a problem with XYZ plumbing, they could picket the gate for XYZ, but they can't picket the gate for ABC because they're not involved in the process. But if you don't segregate the gates and everybody enters through the same gate, then you might find that even though ABC is not directly involved in the process, their employees may be sympathetic with the employees of XYZ and may refuse to cross the picket line. So that's one of the reasons why you see those segregated gates. And also cannot ask other labor groups to strike or boycott to force unions' recognition. Again, these are what the law says. As we all know, there's been a boycott against Coors that's probably approaching 40 years old now because they refuse to negotiate with their employees. And other unions will try to force people or impress on people the impropriety of buying Coors beer. So I suppose the technicality there is the union that's trying to negotiate with Coors maybe didn't ask the other ones, but there's certainly a sympathy there, so the net result is the same. The bargaining process requires that employers meet with the representatives of the employees, the union, and negotiate in good faith. They require that you per se agree to anything, but you have to negotiate in good faith to the point of impasse, and we'll talk about impasse in just a second. Once you have negotiated a contract, you're required by law to sign and comply with the labor agreement that resulted from your good faith negotiations. You are required to notify the union before the labor agreement terminates if the employer seeks changes and then negotiate over the terms of successive renewal contracts. Those are often referred to as demands. What that means is if your contract is set to expire on 12/31, now is when you should be saying we need to have a reduction in our pension costs or our retirement insurance. So the idea is to try to resolve as many issues as are possible before the expiration of the contract. Doesn't always happen, but that's the legal requirement. You're required to notify the union and bargain over operational changes that affect mandatory subjects of bargaining. So what that means is we may be, let's say, a national company, and we decide to shut down the Helena, Montana office of our particular organization. The sense of the law is the decision to shut down the office is uniquely the employer's, but you have to meet with the union to talk about the effects of the shutdown. So the effects might be things like, are your employees going to be able to get transfers to other locations? Are they going to get severance pay? Will they get bumping rates if they're more senior than somebody does the same job in another location? So those things would typically be mandatory subjects to bargaining, and you would be required to negotiate the effects of the down, even though you may not be required to negotiate the decision to shut down. So you're also required to deal with the union on contractual grievances and issues that arise during the administration of the agreement. You typically see that there are two kinds of grievances. There's what's called interest arbitration, and there's what's called grievance arbitration. Interest arbitration are grievances that result from the process of negotiating the contract. Grievance arbitration are issues that arise from the application of negotiated contract. So, for example, if the union wants $1 an hour raise, management's offered 50 cents an hour, they submit to arbitration to find a number that both sides can agree to. That would be known as interest arbitration. But if there's a provision in the contract that says that when we shut this office in Helena down, we laid people off according to seniority, and somebody believes that seniority was not applied, that would be a grievance arbitration if it wasn't so short of the arbitration process. Required to disclose information to a union that's relevant to the negotiation or the administration of the collective bargaining agreement. So, for example, things like we deducted the following dues from employees would be something that the employee is entitled to because it directly has to do with the administration of the contract. Or there's a list of the newly hired people that were hired into jobs covered by the collective bargaining agreement so that the union can reach out to them and integrate it into their particular program. So with bargaining, there's additionally 3 types of topics that are talked about. One, mandatory subject to bargaining. We just talked about that just a second ago. Mandatory subjects of bargaining are things that have to do with compensation and benefits, with hours of work, and other terms and conditions of employment. That's interpreted very broadly. So, other terms and conditions of employment can be things like how much do we charge for the Pepsi that's in the machine that's located in the employee break room? That's considered to be a term or condition of employment. What are the uniform requirements? Are people going to wear this shirt or that shirt? Are things that are considered mandatory subjects of bargaining. So an awful lot of things fall under mandatory subject to bargaining. Permissive subjects are things that may be raised by either side, and either side is certainly allowed to discuss them, and if you get agreement, the terms can be included in the collective bargaining agreement. But unlike mandatory subjects, which you are required as a matter of law to meet and discuss, permissive subjects, if one side doesn't wish to talk about them, they can just decline, and there's no legal responsibility to move further. So things that fall under permissive are things over which management typically exercises sole control, such as product design or the placement of union labels on products. So I'm sure you've all seen things like what's known as the union bug that certain union print shops would often put at the bottom of things that they print, like forms or newsletters, that sort of thing. Market strategy, business closing, union representation on the board of directors, retiree benefits. So if one side says, hey, we'd like to talk about having a union representative on the board of directors, management can say yes, management can say no, but if they say no, that's the end of it. The union has no ability to file an unfair labor practice, as they would be able to do if, say, we need to talk about a cost of living increase, and management says no to that. That would be an unfair labor practice. There are certain subjects that are illegal to put into a collective bargaining agreement. So any subject that would produce an illegal or unenforceable contract where employees or management has a statutory right. Example of that is states are what are known as right-to-work states. In a right-to-work state, there's a state-level prohibition against having a union security clause in a contract. So if it's against the law locally, then the union could not mandate that the employer discuss union security. Union security is the term used to describe the requirement that people who work in bargaining unit jobs either join the union, which is known as a closed shop, or pay alternate payments if they don't choose to be a member, which is usually referred to as an agency shop. So a closed shop is where you have to be a member, but some people have political, religious, other kinds of opposition to being part of a union. And so, as far as I know, every state prohibits closed shops. So if you want to pay $25 to charity in lieu of being a member of the union, you can do that. But it's important to remember that the balance here is unions are required to represent all of the members, whether they pay dues or not. So if you end up in some sort of a dispute with the employer, the union still has to represent you, even if you're in a right-to-work state. Lateral changes we've spoken to a little bit, but lateral changes are, again, where the employer makes a change without having consulted with the union with regard to mandatory terms or conditions of employment. So maybe it changed the pay rate, the reimbursement for expenses, or the promotion process, or those kinds of things. So employers are not free to change mandatory terms or conditions of employment without first consulting with and or negotiating with the union. To do so is actually unlawful. Despite the general prohibition, there are a limited number of circumstances under which a employer can engage in unilateral conduct. This is where the parties have reached a genuine impasse in the negotiations. So the term impasse refers to you negotiated over something, you can't get to an agreement, and there's been no movement towards an agreement for a period of time. So again, the union wants $1, refuses to drop below $1 an hour increase. Management's offered 50 cents and refuses to go above. If you get to a scenario where there's just no more movement, that's considered to be an impasse. So the employer generally likes impasse because if there is a genuine impasse, the employer can implement its last offer. So typically you end up with things known as throwaway issues. And throwaway issues are things that are put on the table. They sure sound serious, but in reality, the union doesn't really care if they get them or not, because what they do is they use them to avoid impasse. So as an example, the union can say, well, live up our demand that you give us a free can of tomato soup every week. Then that was progress. So that would not be an impasse because progress has been made. So the employer generally likes impasse, the union generally does not, because impasse allows the employer to implement their last offer unilaterally. You also can make unilateral changes when the change is consistent with established past practice. So if you've always done something in a certain way, then the employer has a lessened burden to show this unfair labor practice due to unilateral conduct. The union can waive its right to bargain. So you can go to the union and say something like, OSHA just changed the rules with regard to hard hats. You guys want to talk about it? And they say, nope, just go ahead and implement it. And in that case, the employer can do unilateral action. Similarly, if the change is required by law, the employer can make the change without consulting with the union. Once an impasse is reached, the duty to bargain about the subject matter is suspended until the impasse is broken. As a general rule, anything that renews the possibility of fruitful discussions will be considered a break in the impasse and render any subsequent unilateral action unlawful. So again, that's why we have these throwaway issues that are proposed, and often see 40 or 50 issues put on the table during collective bargaining when the union would actually settle for getting 2 or 3 of them. The rest of them are simply there to avoid the occurrence of impasse. In the public sector, the National Labor Relations Act does not apply. Those employees, if they are covered at all, are covered by state law. So in the state of Montana, for example, we have something called the Collective Bargaining for Public Employees Act that allows Montana state employees at the state and local government level to enjoy most of the same privileges that private sector employees have, but certainly not universal across the country. You may recall about a year ago, the governor of the state of Wisconsin and in the state of Indiana and last week the state of Michigan all passed laws restricting the right of public sector unions with regard to their ability to negotiate or go out on concerted action. It's very generally true most states do not allow public safety employees to strike. So in most states, the Highway Patrol, the state police, prison guards, those sorts of folks are generally prohibited by law from striking. In the state of Montana, the only group of people that we prohibit from striking are nurses if the next healthcare facility is more than 100 miles away. So that's sort of a public protection kind of thing. We're not going to let people suffer life safety events as a consequence of the collective bargaining process. So the public sector unions arose in 1820, and you'll never guess where, in the state of Wisconsin is where they came from. In 1912, the La Follette Act gave employees the right to organize in the federal sector. JFK gave federal employees the right to collective bargaining in 1960 through use of an executive order. And you recall a couple of weeks ago when we talked about the sources of employment rules, executive orders have the force of law unless Congress or the courts say otherwise. Bargaining is more difficult in the public sector due to the split authority of the executive and legislative branches. We've certainly seen that in the state of Montana the last couple of years, where the executive branch is headed by a Democrat and the legislative branch is headed by Republicans, and the Republicans aren't about to approve something negotiated by the Democratic governor. So it creates difficulty in the collective bargaining process because the governor negotiates but has no authority to really promise anything. So in a lot of cases, the union just goes straight to the legislative branch with their demands. New employment policies and practices. One step that relates to employment practices is the term called employment at will. So employment at will exists in every state except for the state of Montana. And what it basically says is that employment continues at the will of both the employer and the employee, wishing the employment to continue. Every state, however, has certain exceptions to employment at will. Those would be statutory exemptions like civil rights law, the National Labor Relations Act. So even though you're an employee at will, I can't fire you for reasons that violate state law. I can't fire you or refuse to hire you because of reasons that would violate the National Labor Relations Act, because you choose to form or not form a union. That's become interesting in recent years there's a concept called salting. And salting is where people who often work full-time for a union go apply for work with a particular employer that are seeking to organize. And those employees even admit in the hiring process that I'm here solely to organize your employees into a labor organization. But if the employer should not hire them, then I have a pretty strong argument that the refusal to hire that person was due to the fact that the employee advocated unionization of the workplace, which in turn would be an unfair labor practice. So whether they're employees at will or not, there are certain things that trump the concept of hiring at will and employment at will. Kind of exception are called common law exceptions. The term common law refers to judge-made law. So common law is the laws as interpreted over the years by the judges of the country. So in the United States, we have a common law that says that employment contracts can be exceptions to employment at will. So an implied contract might be in the form of a handbook statement or an oral representation. A good example of an implied contract is in Montana back in 1982, a case in which an employee was fired, but that particular employer had a statement in their employee handbook that said good employees can look forward to a long and prosperous career with our company. And because the employee got fired, but there's nothing in the file that showed that they were not a good employee, the court found that was the violation of the implied contract that was contained in the handbook. The concept of good faith and fair dealing is a concept that's largely an insurance concept, but what it basically requires is that employers act in good faith and deal fairly with employees. The covenant of good faith and fair dealing applies in many states, not all, but many, Montana being one of them. The Montana Supreme Court recognized it in a case called Gates versus Life of Montana 2, the second version of the case, that was cited back in 1982. And so he said that every employment relationship contains this requirement for employers to act in good faith and to deal fairly with their employees. So just in the last couple of days, in this office, we've been doing investigations, and we've noticed that in some of the investigations, the employer didn't do things fairly. They didn't completely investigate alleged misconduct, and that's very likely a violation of the covenant of good faith and fair dealing. And in the case called Crenshaw versus Bozeman Deaconess Hospital, the person who was fired was a probationary employee, and the Supreme Court of the state of Montana said the covenant of good faith and fair dealing trumped even the fact that they were probationary. So you still had to treat them fairly and deal with issues thoroughly and not negligently. The concept called promissory estoppel is a legal principle where an employee lies on a promise which ends up resulting in their injury. Promissory estoppel might be a situation like somebody says that I'm prepared to hire you, go ahead and give notice. They give notice, and then I pull the rug out from under them because they relied on my promise. They're now without employment. That may be an exception to the normal concept that I can terminate you anytime I want without liability. There's also arguments that decisions to terminate in violation of public policy can be violations of employment at will. For example, back in 1959, there was a case called Peterman versus the Teamsters, where the employer had directed one of their employees to go testify in court in a case that was filed filed against the Teamsters, and they wanted him to testify in a particular way that Peterman thought was untrue. And when Peterman refused to testify, in his mind, falsely, he got terminated under the concept of employment at will. But the court said, we can't allow employers to hold employees hostage because they refuse to lie in court. Doing so would be a violation of public policy. So there's a number of exceptions. Pretty much whenever the law grants somebody a right or a privilege, if an employer acts in a way to deny that right or privilege or to pull the expression, in other words, make the employee reluctant to use it, that's considered a public policy issue. So I have an employee that's in the National Guard, and I let them know that I really disagree with that. That could be a public policy issue. Or if a person goes on jury duty and I let them know that I'm displeased with that, that can be a violation of public policy. In some employment at will cases, the court have declared that there are tort theories that apply. A tort is defined as one party has a responsibility to another party and has somehow breached that responsibility. So, for example, back up to the covenant of good faith and fair dealing, if an employer does not act in good faith and fairly, that can be the violation of obligation to do so. The important thing about torts, as distinguished from contract actions would probably result in a directive from the court to put somebody back to work, perhaps with back pay. Tort is considered more serious, and if you're guilty of a tort violation, typically include payments for emotional distress, defamation, compensatory damages, punitive damages, those sorts of things, which can make the significantly more expensive for the employer that's found guilty of the tort violation. Employees are viewed as having certain rights, and these rights certainly vary from state to state. And since we're largely going to be tested, or almost exclusively going to be tested on federal law in the HRCI test, we're just going to talk about it with regard to rights that tend to exist across the country. We have privacy, but at the federal level, privacy is not an explicit right. It's something that was created by the courts. So unlike the state of Montana, where we have a privacy provision written right into our state constitution, at the federal level, privacy is considered to be what's called a penumbral right. So the Supreme Court has said the other kind of rights make no sense if there is no right of privacy, but because a penumbral right is opposed to an explicit constitutional or statutory right, the court or the Congress can change that anytime they want to. But the way privacy rights typically arise is privacy in communications, drug and alcohol, polygraph tests, those kinds of things where the employer seeks to violate the privacy of one of its employees. One of the areas that's brand new and rapidly expanding is the intersection of employees' rights with regard to social networking. Examples would be employers who seek to or demand to have access to an employee's Facebook account or web page or personal email account come under a couple of federal laws. One's called the Electronic Communications Privacy Law. The other is called RICO, and RICO stands for the Racketeering Influence Corrupt Organizations Act. But in certain cases, if employers listen into private email conversations or phone calls, it's considered to be unlawful wiretapping under RICO, and the employer can suffer some pretty serious types of consequences, because you are then viewed as being really no better than, mob or other unlawful organizations. In public employment, you have a concept called good cause and due process. And the concept of due process is one that's guaranteed by the Fifth and the 14th Amendments to the U.S. Constitution. And particularly, it requires that employees have the right to know charges about them and to respond to charges before disciplinary action is taken. So due process is a public employment concept. Good cause is similar, and it applies in the state of Montana, for example, to everybody covered by the Wrongful Discharge from Employment Act. Other than Montana, it's largely a concept that's associated with collective bargaining, because most collective bargaining agreements require that good cause or its close relative just cause be present to justify terminations or other kinds of losses of property like suspensions from work. Other rights that employees have is access to benefits on a non-discriminatory basis. So ERISA would be they have access to things like retirement plans. They have HIPAA provides for things related to privacy of medical information. They have freedom from job discrimination. They have legal rights to work in a safe workplace. They have the legal right to organize under the National Labor Relations Act. And then contracts or policies that they work under may add other rights to those granted by statute. Talk a bit about performance reviews, performance appraisals. There are a number of different kinds of systems. The most common are the traditional supervisor-subordinate relationships, where the supervisor reviews whether or not subordinates met expectations, exhibited proper conduct. You also have what are called 360 plans. They're alternatively known as team or peer ratings. So the concept 360 refers to 360 degrees of a circle. So that's where everybody that you come in contact with is asked for input with regard to your performance. Evaluations is the concept that you ask subordinates of people to rate their supervisor. Ratings is where you ask people to view their own performance with regard to hopefully pre-established criteria. Outside ratings refer to getting input maybe from a survey or from other kinds of feedback mechanisms from people outside your organization, like your customers. So those of you that have attended training that I do know we often hand out evaluation forms. That's a form of a performance review from the people who used a particular service, i.e. a training service. There's a number of methodologies that can be used to do performance appraisal. One called a graphic rating scale. A graphic rating scale can simply be 1 to 10 in the form of numbers. A system is similar. The difference between a graphic rating scale and a bar system, which is the second to the last one listed here, is graphic rating scale would say rate the person 1 to 10 on performance, but it gives no particular indication as to what kind of performance merits a 10 versus 9 versus an 8. A bar system might have at least some of the points labeled to say, if this is true, they get a 5. If this is true, they get a 7. If this is true, they get a 10. So BAR stands for behaviorally anchored rating scale. So it's a graphic rating scale that simply has identifications along the scale to help the person performing the review to assign a number and hopefully letting them assign numbers in a consistent system when they have more than one person to review. A checklist kind of methodology lists statements, and the supervisor simply usually checks the box next to the statements which best describe the person being appraised. So one statement might be something like, is always present except for when absences have been pre-approved. And that's what you think describes the performance or conduct. That's the box you check. And there's a variety of those kinds of statements on the form. You check the ones that best describe. A first choice is where there's two options and you're required to choose one or the other. It's closely related to the force distribution, which might say something like, if you have 10 employees, you can't rank more than 2 of them as superior and not more than 2 of them as substandard. So it tries to force rankings into the bell-shaped curve, which traditionally describes most human attributes. So the full force choice says you either have to choose A or B. You have 2 choices for each dimension that you're ranking. Force distribution would limit how often you can use a particular ranking on the theory that in the real world, not everybody is outstanding. And if we limit the number of people that you can view as outstanding, that gives us a better look at the real world. MBO is a type of a system. MBO stands for Management by Objectives, and MBO type of a system is where you typically identify goals and time frames. So it might be expressed in the sense of this project needs to be accomplished by this date with this amount of time being spent or this amount of financial resources or other identifiable kinds of resources. Some of the errors that you'll hear described with regard to performance appraisal, the first one is the use of different standards for different people. Obviously, that's not particularly recommended, but we still find people who say things like, this one has a degree, they're capable of so much more, so I'm going to write the standards differently for them than I am for the person who has the same job but doesn't have the degree. So that's probably a legal violation. The recency effect is a person at recent behaviors that may not be typical of the entire rating period and uses the most recent behaviors as basis for rating the entire period. So maybe you have somebody who, for the course of the year, has been substandard with regard to the number of widgets that they make, but in the 2 weeks after, before you do performance appraisal, because they know reviews are coming, their productivity improves, so you rate them as acceptable based on the last 2 weeks worth of behavior. That's an error because it doesn't properly describe the totality of their behavior over the entirety of the rating period. The called central tendency error. So if you can think of your mind of a rating scale that goes from 1 to 5, with 1 being low and 5 being high, central tendency is where a supervisor rates everybody as of 3. And they don't want to play God as a common statement made that everybody's okay. So the problem with that kind of a scenario is if you have an employee who's really performing at a 5 level, but they're only being recognized as performing at a 3 level, the reinforcement they receive is such that, why should I be working so hard? It's not going to do me any good. And conversely, the person who's really performing at 1 level has no incentive to get better because they're already being recognized as being acceptable. Rate bias is where people rate people based on things that they like or dislike, which often it can be similar to the contrast error. It's sometimes known as contrast and similarity error. So people tend to rate things more positively if those things are similar to themselves. So a white person would rate a white person more if they don't have a good system. A person who went to a given college is going to probably rate other people who went to the same college higher than people who went to a different college if they don't have a system that's more precise, if it's just based solely on do I like you or do I not. The halo effect is typically for employees we might rate 8 or 10 different dimensions of performance. And halo effect might be something like, well, this person's just really, really friendly, and because they're really good at one dimension of the job, you tend to give them a pass on all the areas where they're not, and you rate them atypically high on the rest of those criteria for performance where it's not warranted by their actual performance. Talk a little about management theory. There will be three main schools of thought that existed over the last 100 years or so. One of them is known as scientific management, and is in vogue from roughly 1880 until perhaps 1930 or 1940. And the view of a scientific manager was that the single best correct way to do everything, and management's job is to identify that best way and force all other employees to do it exactly that way. Humans are viewed as tools with few, if any, rights. Supervisors tended to believe productivity and motivation were externally generated. In other words, I can cause you to be productive, I can cause you to be motivated through things like manipulation of your pay or discipline or threats or waving carrots in front of you. By the time we got to World War I, we started to realize that that system didn't really work. It didn't allow the United States to gear up the productivity that it needed to fight the war. So we started to see the first efforts at decentralization of management. So in the 30s, we started to see some of the first advocates of involving employees in problem solving. In other words, if you have a problem with an employee, sit down and talk with them, try to identify what the issues are and address issues that exist solely with one employee. One of the first proponents of that was a woman by the name of Mary Parker Frey. She was largely run out of town because if you remember in the 1930s, that was the rise of Bolshevism, and people thought that involving employees sounded socialist to them, and they really wouldn't accept it. But at least in the academic world, that helped give root to the theories that later on became known as the behavioral school of management. So the behavioral school of management probably started to come into ascendancy in 1940s, 1950s. One thing that you may hear about is something called the Hawthorne studies, alternatively known as the General Electric studies. And GE had a whole bunch of factories, and they were really into the concept of trying to decide how to best manage people. So what they did is they took a given factory and used a given style of management and then compared the various records of the different factories to try to identify what management rates resulted in the greatest productivity. And what they determined was that productivity was as much related to social and psychological factors as it was to identification of that single best way of doing business. That motivation was strongly influenced by things like the quality of supervision and interaction with peer workers. And they found that things like pay, hours of work, varying rest periods. They also looked at things like 10-hour work days versus 8-hour work days, varying the amount of light in the workplace, all kinds of things. But they all found most things had very little effect on motivation and in turn on productivity. So a lot of people today still think you can buy productivity, that if you pay people more, you'll necessarily get higher levels of productivity. I don't know that that's entirely true, maybe for individuals, but I think most of you would probably agree if you doubled your pay tomorrow, you probably wouldn't work twice as hard. You'd certainly accept money, but all we're doing is throwing additional money at the same end results, and it has very little to do with the increase of ultimate productivity in the workplace. We, in the 1960s, had an author by the name of Douglas McGregor who came up with what's referred to as theory X and theory Y. And the way he viewed the world is theory managers, and this is largely the folks who practice scientific management. Theory X management style view workers as lazy and believe that supervisors must use their authority to produce good work. So the ones that have their whips out all the time, they're the ones that fire people who don't do things exactly their way. The Y method management has a belief system that thinks that workers seek responsibility and ingenuity is widespread in the workers' population, and management's job is to figure out how to turn that on, but they can't directly control productivity. Then about 20 years later, another author by the name of Thomas Ucci wrote and created a concept called Theory Z. And Theory Z is really Japanese management style, which is a certain degree a misnomer, because what we think of as Japanese management, American management we sent to Japan after World War II, got mixed with Japanese culture and got sent back to us as Japanese management. But anyway, Theory Z believes in group consensus and decision making, and see the use of things like quality of work-life programs, quality circles where employees work together, discuss how to improve the quality of the widgets that they're producing, that sort of thing. Today, in the 21st century, we have a whole new set of issues that have to deal with. Today's supervisory environment, we have labor market issues that really never existed. I remember recently, as 7 or 8 years ago, most of HR planning dealt with where are we going to find the entry-level workers. That was before we got into the recession, which is sort of a blip in the normal evolution of things. But I probably mentioned in a prior session, at least in the United States, families aren't having the required 2.2 kids that it takes on average to maintain the size of the labor force. So labor force has been shrinking, and that's resulted in fewer entry-level workers to do jobs that entry-level workers typically do. Additionally, we have issues like the fact that we've been in war for the last 10 years. Like it or not, the military sucks up a lot of entry-level workers, and they're out of the labor force for 2 or more years. All of those things create labor market issues that supervisors today have to deal with that did exist previously. We all have increasing worker diversity. Remember in the mid-'80s, 42% was the number that described the percentage of the labor force that was female. that same percentage today is much closer to 50%. It's in the high 48% range. More and more women in the workforce than previously, older workers in the workforce. If you look at places like Walmart, the greeters who are typically semi-retired individuals, I feel reasonably comfortable in saying Walmart didn't start doing that for any reason other than it had difficulty finding other entry-level workers. The same thing with the increasing use by companies like McDonald's of people with disabilities. It was largely the shortage of regular, traditional entry-level workers that caused them to start recognizing these other components of the labor force. So diversity is another thing that employers have to deal with. Globalization of the workforce. We have workers here in Helena from other countries, and the people who manage those individuals have very different kinds of issues than have ever existed before. We have one customer that we work with, that has a lot of employees that come from Pakistan and from India. So you have Pakistanis who are Muslim, you have Indians that are Hindu. There are a lot of religious elements that come into the workforce. More and more employers are having to deal with Muslims wanting to pray 5 times a day, and that shuts down the production line while they do so. Things like the people who are Hindu have a predestination. They believe that the future is preordained by God, and very little that they can do will change that. So it's harder to say things like go, as in their mind, anything that they do doesn't change the future. That's an attribute of the culture that they grew up in. We're more moving from manufacturing to knowledge industries. It used to be the supervisor was a person that was the guru of whatever part of the business that they managed. It is now much more common for employers to hire people because they have an expertise that the employer does not have. So, for example, you hire an IT person because you're clueless with regard to IT. So that makes supervision a very different kind of issue because you can't oversee the technical aspects of the job. You have to find other ways to do so. As is no surprise to any of you, there's increased emphasis on employee rights issues, discrimination, privacy, those kinds of things. Just as importantly, employees have a very different set of expectations of the people that they work for. Most employees want to work for employers that are socially responsible. So for a lot of employers or employees, it's just as important, what are you as my employer doing to help out the environment, to help out poor people, those kinds of things. Those didn't used to be issues, they are today. Employees increasingly expect a voice in workplace decisions, and they expect a recognition that they have a life outside of work, and they need some balance between work and home. It's probably approaching infamous that IBM used to actually have a ceremony where newly hired employees went through what was referred to as a marriage ceremony, where they had to marry the company, and they were told that a year from now, you're probably going to be divorced and probably going to have all of these issues because we own you 24/7. That view of things doesn't lie so much these days. A couple of years ago, Walmart started a new thing where they did, at least on a test basis, requirement that all employees had to be willing to be called in at any time during the week for any shift. And then they put in place some new software in some stores, and that software would look at sales by the minute, compare them to the prior year's sales, and if there is a prediction that they were busy or the computer would reach some employees to work, sometimes for as little as an hour or two. But if employees weren't willing to be summoned, they couldn't work for Walmart. Probably no surprise that didn't turn to be successful because a lot of employees weren't willing to say, "She'll come in on Christmas Eve if you're busy." Kinds of things relate to motivation in the workplace is a concept of organizational commitment and how it relates to performance. There's different kinds of organizational commitment. One's referred to as effective commitment. That's just people who just like what they do. You see that a lot in nonprofits. You see that in organizations, social service agencies. For example, one of the people on the call today works for Minden Home, and pretty close to universally everybody that I've ever spoken to there talks about how wonderful it is to work and all of the the feedback that they get that makes them feel like they're making a difference. So people stay and they produce because they like what they do. There's other people who stay from sort of a golden handcuffs kind of a perspective because they can't find another job or they need the benefits, they need the salary. So that's referred to as continuance commitment. They feel like they need to continue because they can't find another job with the same pay, the same benefits. And then other people have what's referred to as a normative commitment, and that relates to a feeling within the individual. It could be religious, it could be the way that they maturated over the years, where their parents say, when you go to a job, you stay with the job and do a good job. And it's not in their psychological makeup to be hopping job to job. As you can probably expect, the commitments that people feel have a lot to do with what they produce. There are individual and organizational exchanges that have a lot to do with job satisfaction and in turn with productivity. So each party in the employment relationship makes demands and contributions to the other. So I, as the employer, have certain demands that I expect my employees to give, and in return I make certain contributions back to them, and it works from the other perspective as well. A concept called equity expectancy is a really strong thing, and I see it so often when employers start changing their organizational structure or their pay systems, that basically equity expectancy is the perception that an employee has that they will receive back from the organization in proportion to what they contribute to the organization compared to what others contribute to the organization. So those fancy words for people have in their mind a pecking order, and they think in terms of, I contribute more than Joe does, therefore I expect to get more benefits back than Joe does. So if the company starts giving a raise to Joe, it doesn't make any difference what the absolute numbers of pay is. We've accepted that equity expectancy, and we sort of instantaneously have dissatisfied employees. Because when the employee perceives an inequality, that tension has to be satisfied in some way, and sometimes it's satisfied with people walking out the door. Sometimes it becomes a matter of dissatisfaction with the supervisor. Sometimes the employees quit, but they don't leave. All kinds of negatives can flow from a violation of equity expectancy. When you talk about equity expectancy, there are probably three subcategories. There's some people who are very equity sensitive. They demand to get exactly the same thing as others all the time. So if you give Joe a raise, you better be giving Mary a raise too, because Mary demands to be paid exactly the same. There are those that we refer to as benevolent. They be an equity deficit, so they're okay if Joe gets a raise and they don't. And then there's the Joes of the world who think that they are entitled to a raise and nobody else is, so they demand more than their share. And each of those are equally valid, but very different kinds of perceptions with regard to equity expectancy. Some other things that have definite impacts on productivity: one, role variables. Some of the terminology you might see on the test. Role ambiguity are issues that arise where people are confused or uncertain about exactly what their job functions are, and that often results in dissatisfaction with the supervisor. So if people are left to have to guess what's expected of them, chances are they won't. They'll fall into line, do the minimum necessary until that becomes clear. Role conflicts is where people have multiple roles and they all require different actions and responses. That could, for example, be where you have two different supervisors and want things to occur that are just unattainable. You do what Supervisor 1 does, you can't do what Supervisor 2 wants. So role conflicts can have a definite contribution towards good or poor performance. Person job fit is the measurement of the similarity or difference between what people are looking for in a job and what they get from a job. The old-fashioned concept of loyalty has largely been replaced by people will work for you for the time that they perceive that the job satisfies their personal goals. When they start perceiving that their goals aren't being satisfied with the employer and can be better satisfied elsewhere, turnover occurs. Work-family conflict is the type of conflict where the demands of work and the demands of a family life are in conflict. I just recently investigated a situation where that came out in very terms. A single mother with issues with kids, and they got very clearly in the way of her doing what the employer wanted, and it's caused all kinds of poor performance, all kinds of conflict between those individuals. Compensation, first of all, as I mentioned earlier, with regard to the GE studies, compensation has some applicability to satisfaction, but others, at least today, can be just as concerned about the process used to establish pay rates and not their fair, not just the actual resulting number of pay. So if you recall earlier, we talked about Maslow and hierarchy of needs, and we talked about other theories of motivation where we talked about what are called motivators and hygiene factors. Pay is viewed as a hygiene factor, so pay beyond what's expected by the employee typically doesn't add additional motivation. So typical compensation packages, while very clearly part of the mix, have become secondary to other kinds of issues in the workplace, such as the employee's desire to know where they fit into the organization. Principles, you know earlier that we talked about Hindus and their predestination concept. Locus of control refers to somebody who's said to have an internal locus of control is somebody who believes that I do affects the future. People who are viewed as having an external locus of control believe that they're governed by external events. So if you're an internal, you generally have higher job satisfaction than if you're an external. But in a lot of cases, being internal or external is something you don't have much control over because it's very, very much related to cultural or religious training and acclimation. Quality of supervision is something that very definitely affects performance of people. Work tend to want supervisors who emotionally mature. In other words, they're predictable. They're not yell at them one time and be nice to them the next time. They want them to be predictable, dependable, cooperative, knowledgeable, and somebody who will level with the employee, both in the sense of being honest with the employee, that sense of leveling, and also somebody who's a supervisor who can view the world through the same glasses that the employee has, because sometimes supervisors are thought to be out of touch and don't know what I face. So those are the kinds of things that can definitely impact quality of supervision. Our main topic is health, safety, and security. So you're probably all well too familiar with OSHA, the Occupational Safety and Health Act, which applies only to private sector employers. So government is not subject to OSHA. Many states extend OSHA-like programs to public sector, but that, just like the National Labor Relations Act, is a state-level decision. We also have the Rehab Act, Drug-Free Workplace Act, Hazard Communication Standards, ADA child labor. All those are laws that have direct implications for safety in the workplace. So OSHA has a number of safety standards. One of those is referred to as the General Duty Standard. So aside from the very, very specific things like if you work on a laundry, you must wear flame-retardant clothing, they also have this thing called the General Duty Standard, which says employers have the obligation to provide employees safe and healthy working conditions. So that's sort of the catch-all standard that if you do things, even though they may not be specifically enumerated in OSHA safety standards, if you do something that results in the employee being injured, often you will be introduced to the General Duty Standard in the sense of an accusation that you violated it. Employees do have the right under OSHA to refuse to perform unsafe work. So if there's, for example, personal protective equipment specified to do a certain job, like you have to have a respirator to go into a confined space, and an employer makes a demand that you go into the confined space without the appropriate safety, employees have the right to say no to that. And that is not viewed as retaliation or as insubordination. Employers have to communicate information to their employees about hazardous materials that employees may come into contact with at the refinery or in the warehouse or wherever they might work, and make material safety data sheets, MSD sheets, available to the employees that talk about what the nature of the hazard is, and also, should they get contaminated by that hazardous material, how to best deal with it, like ashes or whatever it happens to be. Employers have to provide specialized personal protective equipment to employees. That standard changed a couple of 3 years ago. It used to be that you had to provide personal protective equipment. The rule now provides that things like safe shoes, things like hard hats can be personal items that the employer can require people to provide. But to the extent it's specialized, not the kind of thing the average employee would have, the employer has the obligation to furnish it and should require that the employee utilize it when performing the job for which the PPE is required. There also has the requirement to control bloodborne pathogens. So particularly in healthcare environments or environments where it's very likely for various kinds of pathogens to be spread, people have to take both preventative types of measures to keep those from spreading, like the wearing of eyeglasses for HRCI dental assistants, the wearing of protective gloves for people who handle food and work as butchers and those sorts of things. So bloodborne pathogens is a whole area unto itself with regard to OSHA safety standards. OSHA enforcement. OSHA has the right to conduct inspections and cite violations, and employers have to keep information and make reports in the case of certain injuries and death. Other than that, most of the reports are created but don't have to be submitted. The OSHA 300, 301 series, that if you're an employer with more than 10 employees and you're not in an exempt industry. Exempt industries might be things like insurance offices or clerical offices. If you're not in an exempt industry, you have to complete and post the OSHA 300 report for a minimum of 3 months beginning February 1st of each year. That format is available electronically now in a spreadsheet, but basically what the OSHA 300 report does is it's information for employees to determine whether they're working in a safe workplace or not, because they can see what kinds of things others have suffered. The employer has to report to OSHA any workplace accident that results in a fatality, and they also have to report if there's inpatient hospitalization of 3 or more employees. They have 8 hours to report those scenarios to OSHA, which results in an immediate response by OSHA to investigate and see whether or not there was preventable injuries. If you are required to keep Indian illness records, you're basically required to keep that classified again in one of those low hazard retail, service, finance, insurance, or real estate industries, i.e. the exempt types of employers. You don't have to keep those unless you've been specifically told to do so by OSHA. Safe management programs, in Montana, if you have 5 or more employees, you're required to have a functioning safety committee. Safety policies and training are typically required activities of those safety committees. Ergonomic assessments are one of the things that you're supposed to do to try to avoid repetitive stress injuries. So looking at how people type, how people do various kinds of actions that they do repeatedly. Drug and alcohol tests are frequently part of safety management programs, particularly in companies like transportation-based companies, railroads, airlines, trucking companies, that sort of thing. There's also the concept of environmental illness, and that's illnesses that are caused by things in the workplace, like smoke, things like hazardous fumes, mold in the air system, that sort of thing. Wellness programs are defined as programs employers engage in to try to keep people healthy. They might take the form of smoking cessation, weight loss, other kinds of things that would hopefully result in people less often incurring medical care. It's often done some part to keep people healthy, some part to relieve charges against their health care program. EAP stands for Employee Assistance Program. That's where employers provide programs that allow people to go outside of the insurance company and the traditional doctor to receive services like mental health counseling or marriage counseling, that sort of thing, that we know all has an impact on people's wellness and also has an impact on their productivity and their conduct in the workplace. Security is defined as the actions that protect facilities from unauthorized access, and they also protect employees while those employees are on duty or on the premise. The concept of workplace violence, we often hear of people going postal, and what was it, just this weekend we had another round of violence at a mall in Oregon where a couple of people were shot by somebody. Workplace violence, interestingly, often is caused by coworkers or relatives or ex-boyfriends, girlfriends, spouses. Those are the prime causes of workplace violence. And that's why increasingly some businesses have controlled access to employees in the workplace to minimize those kinds of exposures to security violations. Background screening is often used for security-related purposes. You're restricted with regard to what kinds of background screening you can do under both things like polygraph laws and laws like the Fair Credit Reporting Act, but typically employee background screening is a recommended component of a good security program. And some places have on-site security personnel. State of Montana does up at the Capitol. They have contract security people. I'm not sure that they would really prevent much workplace violence, but at least there's somebody close to get on the phone and call law enforcement should there be an incident. If federal contractor, there are certain requirements over and above those that apply to all other employers and include the requirement to submit an EEO-1 series report. The reason I say series is because altogether there's 6 different reports. There's EEO 1, 2, 3, 4, 5, and 6 that are all part of this series. The one is the report done by private employers. The EEO-4 report is done by state and local governments. There's ones done by unions, one done by higher education, and so on. But the requirement to do that report is triggered by virtue of you being either a governmental contractor or a large employer, as an employer with 100 or more employees. Similarly, the VET 100 report, which is required to be submitted September 30th of every year, is required only of governmental contractors with 25,000 or more in contracts. And it's 20,000 or more if you have an old contract. If a contract dated since December of 2003, it has to be in the amount of 100,000 or more for you to be subject to the VET 100 report. Fraction plans are out there, but they're only required if you're a service and supply or construction contractor to federal government, or alternatively, if you're a federal depository, which refers to the fact that you're some sort of a financial institution that allows federal government agencies to make deposits in your bank. So if you're the bank where the Forest Service puts the money that they collect from campers, that makes you a federal depository, which in turn makes you a federal contractor and requires you to submit these kinds of reports. So these are affirmative reports. These are things that you have to fill out and submit. Other things you just have to keep records of. Let's see, compensation. I think we already talked about most of these. These must be, unfortunately, duplicates. I apologize for that. So I think that's the material that we intended to cover today. So we'll open the microphone if anybody has questions or comments on this material. So we got Marlena, Michelle, Tanya, any of you. Anybody have questions or comments? It is well recorded today, so I'll send that link out to people probably this afternoon or tomorrow morning. Marlena says no questions. You're Marlena for being a participant and listening to me for 6 hours. You get a brownie point for that. I mentioned that if to the degree any of you are anywhere close to Helena, tomorrow our annual Christmas reception. So feel free to swing on by, and even folks from out of town. We've got people coming from elsewhere in the state, so we'd sure look forward to welcoming people from Pasta, Montana, or Montana Refining, or even from the hospital in Sydney that are on the call today. So will you have your meatballs? The answer is yes, they are already cooking, and my staff is already complaining about having to sit here and sell it while they work. Questions, feel free to send me questions afterwards. Again, I'll send you the link to this so you can listen to it again. If you didn't get the links to the earlier two, let me know. And I guess it's my hope that this in some small way helped you be successful in preparing for the test. So thanks a lot for participating. We'll talk soon.